The phone call came on a Tuesday afternoon in March, 3 weeks after Ruth Calloway had moved into her son's spare bedroom to recover from hip replacement surgery. She was propped against the headboard with a heating pad across her lower back and a legal thriller she wasn't concentrating on when her mobile rang. The name on the screen was Pauline, her neighbor from across the street, the woman who had been collecting her post and watering her indoor plants for the past 3 weeks. "Ruth," Pauline said, without preamble. "I didn't want to say anything before, because I thought it was probably a relative or something. But I saw a young couple moving boxes into your house on Saturday, and then on Sunday there was another car there most of the day, and the lights have been on in the evenings. I thought you should know." Ruth set the legal thriller face down on the bedside table. "What did the couple look like?" she asked. Pauline described them. Young, probably late 20s. The woman had red hair. The man had driven a dark blue hatchback. They had brought furniture, including what looked like a double mattress wrapped in plastic. "Thank you, Pauline," Ruth said. "I'll look into it." She ended the call and sat very still for a moment, the heating pad warm against her back, the afternoon light coming through the curtains of Kevin's spare bedroom. Her front door key was on the key ring in her handbag on the chair across the room. She had kept it with her throughout the recovery because she had assumed she would need it when she went home. She had been assuming she would go home for 3 weeks now, and every time she raised it with Kevin, something new had come up. The stairs were still a concern. The physiotherapist had said to give it more time. The doctor wanted another review. She reached for the keyring, wrapped her hand around the house key, held it. Then she picked up her phone and began to search the local rental listings. Ruth Calloway was 65 years old and had spent 28 years as a legal secretary at Hargreave and Morris, a family law firm that handled divorce settlements, property disputes, custody arrangements, estate planning, and the full range of circumstances that arise when families stop trusting each other and start needing documentation. She had worked for 3 different senior partners across those 28 years. She had prepared hundreds of legal documents, had sat in on client consultations, had typed letters that altered the financial trajectory of people's lives, had organized evidence files for cases that turned on the precise wording of a clause she had drafted. She understood legal procedure not as an abstraction, but as a practical system, what it could do, how it worked, and what the absence of a signed document actually meant for the person who needed one. Over those 28 years, Ruth had developed a particular kind of knowledge that is hard to describe to people who haven't spent a career inside a legal office. The knowledge of how situations actually resolve, as opposed to how they seem like they should. She had seen families torn apart over assets worth very little because someone had failed to sign a document at the right moment. She had seen large estates protected cleanly because one careful person had kept meticulous records. She had seen custody disputes hinge on the wording of a single sentence. She understood that the law was not complicated as a rule, but that most people made it complicated by acting before they understood their position, by speaking before they had evidence, and by making decisions based on emotion rather than the specific, verifiable facts of the situation in front of them. She had spent 28 years helping other people avoid those mistakes. She was not going to make them herself. She had retired 2 years ago, not because she had lost interest in the work, but because her hip had been giving her increasing difficulty, and her GP had finally used the word surgery clearly enough that she had stopped finding reasons to defer it. The procedure had gone smoothly. The recovery was slower than she had hoped. 6 weeks of limited mobility, physiotherapy twice weekly, stairs to be avoided where possible. When her son Kevin had suggested she come to stay with him and his wife Sandra for the recovery period, Ruth had agreed without significant deliberation. She and Kevin had always had a relationship characterized more by practicality than by warmth, not because they lacked affection for each other, but because they were both people who expressed care through action rather than conversation. Kevin had been a steady, reliable presence in her life. He appeared when she needed something moved, called when there was a logistical question, remembered her birthday without being reminded. She had thought of this as a form of dependability that she trusted. She had not, before this, had any reason to examine what it might look like from the other direction. whether the steadiness was mutual, whether it extended to the situations he needed her not to ask about. Kevin was 40, a project manager for a construction firm, methodical and reliable in the practical ways that made him effective at his job. Sandra was 37, a dental hygienist, organized and calm. Their house had a bedroom and bathroom on the ground floor. It was the sensible arrangement. She had not given Kevin a key to her house. She had not asked him to look after the property in any formal sense. She had left Pauline across the street with a spare key for emergencies, and she had told Kevin, in passing conversation the week before the surgery, that there was also a spare key in the ceramic pot by the back door, because he had asked where it was. She had not thought much about this at the time. She had been in Kevin's spare bedroom for 22 days when Pauline called. The recovery had been quieter and more isolating than she had anticipated. She had books and her phone and the television in the spare room, and Kevin and Sandra were considerate hosts in all the practical ways: regular meals, lifts to physiotherapy, a general attentiveness to whether she needed anything. But she had noticed, over those 22 days, a faint texture of arrangement to her stay that she hadn't entirely registered at first. Questions about whether she was comfortable, whether she felt ready, whether it was too soon to think about going home, asked by Kevin with a frequency and a particular careful framing that she had not thought much about at the time, because she was recovering from surgery, and she had assumed his concern was straightforward parental attentiveness in reverse, a son taking care of his mother. The Clifford Avenue house was listed on 2 rental platforms. She found both within 4 minutes of searching. She had known what she was looking for, and she had found it. And the speed with which the search had confirmed her suspicion was not satisfying in any way she would have chosen. She had been hoping Pauline was mistaken. She had been hoping there was an explanation she hadn't thought of, a family friend using the house with informal permission, a temporary arrangement she had consented to in some post-surgical haze she had since forgotten. The listing put all of that beyond reasonable interpretation. 3-bedroom semi-detached, described as 2 bedrooms and a study, monthly rent £950, available from 2 weeks ago, listed by a private landlord, contact number provided. Ruth looked at the contact number. Then she dialed it. A man's voice answered on the 3rd ring, Kevin's voice. She ended the call without speaking. She sat with the phone in her lap and her house key in her other hand for a long moment. She thought about the conversation at the kitchen table the week before the surgery, when Kevin had asked where the spare key was, and she had told him about the ceramic pot by the back door without thinking much about it, because she had trusted him completely and had no reason at that point not to. She thought about every time over the past 3 weeks that she had said she was feeling well enough to think about going home, and the way Kevin had found a new reason each time: the physiotherapist, the doctor, the stairs, the need to be cautious, that she had accepted because she was recovering from surgery and he was her son, and it had not occurred to her that his reasons might not be his real reasons. The heating pad had gone cold. She did not move it. She thought about 28 years of family law and about the specific and very clear legal position of a homeowner who had not signed any authorization, transfer, tenancy agreement, or power of attorney. She thought about the cases she had documented over the years, elderly parents whose children had made decisions about their assets without consultation, property matters that had unraveled precisely because nothing had been put in writing, situations that had seemed complicated until you reduced them to what had actually been signed, and by whom. Her house was hers. Kevin had no legal authority over it. He had used the spare key she had mentioned in passing, let strangers in, and was collecting rent on a property he did not own. She had typed up documentation for cases exactly like this one. She knew what it was. And she knew, with the calm precision of someone who had spent nearly 3 decades working inside the legal system, what to do about it. The first thing she did was call Pauline. She asked 3 things: to note the registration numbers of vehicles regularly parked at the Clifford Avenue property, to photograph anyone coming and going if it could be done without drawing attention, and to contact Ruth immediately if any official-looking correspondence arrived. Pauline, who had known Ruth for 11 years and understood her well enough not to ask unnecessary questions, said she would do all three. The second thing Ruth did was call Gerald Hargreave. Gerald was 71, semi-retired, still in the office 3 days a week. He had been Ruth's direct supervisor for 14 of her 28 years and had said at her retirement dinner that she was the most thorough legal secretary he had worked with in 40 years of practice. She had not spoken to him since Christmas. She explained the situation in the same format she had used to brief him on cases throughout her career: chronological, factual, without editorializing. He listened without interrupting. When she finished, he asked one question. Had she signed anything? Any authorization, management agreement, tenancy consent, power of attorney? Nothing, Ruth said. My name is the only one on the deeds. There is no document of any kind that gives Kevin any authority over the property. Then your position is straightforward, Gerald said. Come in when you're ready. Andrew Fielding is still with us. Property matters. Don't say anything to Kevin until you've spoken to us. She thanked him and ended the call. She sat for a moment after ending the call, still in the spare bedroom with the door closed, and thought about the fact that she was 65 years old and sitting in her son's house, dealing with a situation that she would have prepared documentation for in a professional context without a second thought. The strangeness of it was not lost on her. She had always been the person who organized the paperwork, who understood the procedure, who knew what the next step was. She had simply never imagined that the family she would be protecting those procedures around would be her own. She put the thought away because it was not useful and opened her notebook. She had carried a small notebook in her handbag throughout her working life, not for anything confidential, but for dates, reference numbers, names, the kind of practical information that needed to be written down because a memory, however good, is not a document. She took it out now and wrote on a fresh page in the same format she had used for case notes across 28 years. Date of surgery, date of move to Kevin's house, date and content of Pauline's call, rental listing details, price, availability date, platform, contact number. The fact that the contact number was Kevin's mobile, her own note at the bottom, underlined once. No authorization signed, no key formally provided, no consent given. She worked through it methodically, then put the notebook in her handbag and went to dinner. Kevin made pasta. He also made garlic bread and opened a bottle of wine and asked whether Ruth felt up to eating at the table rather than in the spare room, which she had been doing most evenings. She said she would join them. She sat at the kitchen table in her son's house and ate dinner with him and his wife and answered their questions about her day and her hip and her upcoming physiotherapy appointment, and she said nothing about what she had found, nothing about what she had confirmed, nothing about the call to Gerald or the notebook she had put back in her handbag. Sandra asked how her hip was feeling. Ruth said it was improving, thank you. She ate and answered questions and asked her own and said nothing about what she knew. She had observed, across 28 years of family law, that the most effective approach to a difficult situation was to have the complete picture before opening any conversation. She did not have the complete picture yet. She needed 4 more days. She had also observed, during those 4 days, the texture of Kevin's behavior at home. He was not uncomfortable exactly. Kevin had always had the quality of composure that made him good at project management, the ability to present a controlled face regardless of internal state. But there were small things. He changed the subject when Ruth asked about her upcoming physiotherapy review. He was on his phone in another room more than usual. Sandra, who was naturally easy with Ruth, had acquired a slight formality in her presence, a careful quality, the quality of someone who has been told something and is trying not to show that they have been told it. Ruth noticed these things and wrote nothing down about them because they were observations, not evidence. She kept observations and evidence in separate categories, as she had always done, because conflating them was how cases fell apart. She had seen this happen in practice, a client presenting their emotional reading of a situation as if it were documentation, a solicitor having to explain that feeling certain something was true and being able to prove it were entirely different things. Ruth had spent her career on the proof side of that distinction. She kept Sandra's slight formality and Kevin's increased phone use as background information, noted but not cited, and focused her energy on obtaining things she could actually document. Over those 4 days, Ruth gathered information with the same patient, systematic attention she had given to casework for nearly 3 decades. Through Pauline, she obtained registration numbers of 2 vehicles, regularly visiting Clifford Avenue, and photographs of 3 separate instances of occupants coming and going. Through a careful call to one of the rental platforms, presenting herself as a prospective tenant unable to reach the landlord, she confirmed that the listing had been active for 5 weeks, that deposits had been collected, and that the arrangement appeared to involve multiple occupants paying separately rather than a single household. The total monthly income from the property was, by her estimate, approximately £1,400. She then reviewed her own bank statements on her phone. Kevin had made 3 deposits into her account over the 6 weeks, £80, £60, and £120, described as house expenses, amounts that were large enough to look like contribution toward utilities and small enough not to attract the attention of someone who wasn't examining them carefully. She had not been examining them carefully. She had been recovering from surgery and trusting her son. She wrote every deposit in the notebook alongside the rental income figures. The arithmetic was straightforward. She also, through a call to her GP surgery, confirmed what she had begun to suspect. Her physiotherapist had documented her as cleared for stair use and a graduated return to independent living 11 days ago. The notation was in her medical record. Kevin had not mentioned it. She had asked him 8 days ago when she might be ready to go home, and he had said the physiotherapist wanted her to give it more time, that the stairs were still a concern. The physiotherapist had written no such thing. She added this to the notebook. Date of medical clearance. Date Kevin had told her she was not ready. The exact words he had used. She visited Gerald's office on a Monday, while Kevin was at work, and Sandra was at her clinic. She took the bus, because her hip was managing well enough for that now, and because she did not want Kevin to see her taking a taxi to the part of town where Hargreave and Morris had always been. She sat in the waiting room for 12 minutes with her notebook and her folder, and felt, for the first time since Pauline's call, the particular clarity that comes from being on familiar ground, from being in a professional context that she understood completely, doing exactly what her 28 years had equipped her to do. She visited Gerald's office on a Monday while Kevin was at work. Andrew Fielding reviewed everything in under 30 minutes. His assessment was direct. Kevin had no legal standing to rent the property, collect income from it, or delay Ruth's return to it. The deposits into her account did not constitute agreement or authorization. The absence of any signed document was entirely in Ruth's favor. She could return to her home whenever she chose, and any suggestion that she could not was without legal basis. Andrew also told her something that was useful to hear from a lawyer rather than from her own reasoning, that Kevin's deposits into her account, while they might have been intended to suggest some form of legitimate arrangement, actually worked against him legally. They demonstrated his awareness that income was being generated from her property. They did not constitute consent or authorization on her part. In some respects, he said, the deposits made the documentary case against Kevin more straightforward, not less, because they showed that he understood money was changing hands and had made a decision about what portion to return without any agreement being reached with Ruth about whether this was the appropriate arrangement. Andrew asked how she wished to proceed. Ruth said she wanted to give Kevin one opportunity to address the situation directly and privately before anything formal was initiated. Andrew said he would prepare a letter documenting the full position, ready to send, but held until Ruth instructed otherwise. Ruth said that was exactly right. She chose a Wednesday evening, when Sandra was at her book club. She asked Kevin, after dinner, if he would sit with her in the living room. She had something she wanted to go over. He agreed with the particular wariness she had observed in him over the past week, the quality of a person who has been half expecting a conversation and is never fully at ease until it has come and passed. She placed her notebook on the coffee table. Beside it, she placed the bank statements with the deposits marked, the rental listing printout, and 2 of Pauline's photographs. "I'd like you to look at these before we talk," she said. Kevin looked at the rental listing first. She watched the precise moment he understood what he was seeing. "Mum, look at everything first," she said. He went through each item without speaking. The bank statements, the photographs, the rental listing, the notebook page with the income calculation. When he set the last item down, he said, "I was going to tell you." "Tell me now," Ruth said. She sat without moving while he gathered himself. She had developed this capacity across her career, the ability to sit in a room with someone who was uncomfortable and not attempt to resolve their discomfort by speaking, because speaking at that moment would have been about her own discomfort at witnessing theirs, not about anything useful to the situation. She had watched junior secretaries make this mistake in client meetings, filling silences with reassurance before the client had said anything worth reassuring. She did not fill the silence now. She sat with her notebook on the table and waited. What followed was the kind of explanation she had observed many times in 28 years of family law, given by someone who had thought about what they would say if confronted, and is now discovering that the version they rehearsed doesn't hold up against the specific facts in front of them. Kevin spoke in sections, revising as he went, adjusting the frame around what he had done, as each part of the explanation was quietly met with something concrete from the table in front of him. He and Sandra had been under financial pressure since the beginning of the year. Sandra's own recovery from a minor procedure had reduced her hours for 2 months, and a cost overrun on a project Kevin was managing had affected his bonus. They had looked at their situation and made a decision. He had told himself it was temporary. He had told himself it was a bridge rather than a taking. He had told himself Ruth wouldn't notice, or if she did, that he could explain it and she would understand, because it was only going to last until they were back on solid footing. He had not asked her. He had not told her. He had taken the key information she had mentioned in passing and used it without her knowledge, and when she had asked about going home, he had manufactured reasons to delay her return because the tenants were on a monthly agreement with a penalty clause for early termination, and he had not wanted to absorb that cost. He had also, and this was the part that came out last, slowly, in a sentence he seemed to regret, beginning before he had finished it, told her the physiotherapist was not satisfied with her progress when the physiotherapist had, in fact, cleared her 11 days earlier. There was also, he said, the matter of the penalty clause. When she had asked to go home, he had checked the tenancy agreement and found that early termination before the end of the 2nd month would cost him £450. He had not wanted to absorb that cost. He had decided instead that the most practical thing was to let the tenancy run its natural course and then tell her the physiotherapist had cleared her. He had told himself this was just managing timing, not deceiving her. He had told himself there was a meaningful difference between those two things. He stopped. Ruth looked at her son. He was 40 years old, and he was looking at the coffee table, and he had the specific, deflated quality of a person who has just heard the full shape of what they actually did, stated plainly, without any of the softening they had been using to make it livable inside their own head. "You told me I was not medically cleared to return home," Ruth said. "My physiotherapy record shows I was cleared 11 days before you said that." Kevin said nothing. "You collected rent on my property for 6 weeks without my knowledge or authorization. You returned a portion of that income to my account in amounts designed not to attract attention. And when I asked about returning home, you provided a medical reason that did not exist." She paused. She had learned, across 28 years of sitting in on difficult client meetings, that the moment between presenting facts and asking someone to respond to them was one of the most important moments in any conversation. You did not fill it. You did not soften what you had said by adding qualifications or expressing sympathy or offering reassurance before the other person had responded. You simply held the space and let the weight of what had been said do its work. She had sat in rooms where solicitors had violated this principle and watched cases weaken as a result. She did not violate it now. Is there anything I have described incorrectly? He looked at his hands. No, he said, the quietest she had heard him speak in 40 years. Andrew Fielding at Hargreave and Morris has prepared a letter documenting the complete situation. I have asked him to hold it, pending this conversation. What I am offering you now is the opportunity to resolve this without that letter being sent. That means the full rental income for 6 weeks returned to my account by the end of this month. The tenants given proper notice in accordance with whatever agreement you entered into, and my return to Clifford Avenue this Friday. That is not a negotiation. It is the minimum required for the letter to remain unsent. Kevin looked up. I'll sort it, he said. I know you will, Ruth said. She stood, gathered the items from the table, and picked up her notebook. At the door she paused. I'm not going to ask you why you didn't tell me you were struggling financially. I think you understand why you didn't, better than I can explain it to you. What I would ask you to think about, before we speak again, is what kind of relationship you want with me from this point forward. Because this was the version that required none of this to be said. There is a different version available, if you want it. She went to bed. She had handled the conversation exactly as she had handled client-sensitive discussions across her career, specifically without raising her voice, without introducing anything she could not document, and without asking Kevin to feel anything in particular. She had not wanted to punish him. She had wanted to be very clear about what had happened and what was going to happen next, and to give him the chance to respond to that clarity in whatever way he was capable of. How he responded was his business. What she required was her business. Keeping those two things separate was the skill that 28 years of legal work had given her, and she had used it tonight as precisely as she had ever used it in a professional context. She lay in the dark with her house key on the nightstand, where she could see it in the light coming under the door, and she thought about the 28 years of other people's family situations she had documented, organized, and prepared for court. She had always done the work with care. She had never expected to apply it in this direction, but she had had it available, and she had used it correctly, and it had been exactly enough. Kevin drove her to Clifford Avenue on the Friday. He had not attempted to renegotiate the timeline or introduce a new reason why more time might be needed. She took this as a meaningful choice on his part, the choice not to compound what he had done by making it worse in the final days. She noticed it without commenting on it. He carried her bag to the door without being asked. He stood on the step while she unlocked it with her own key and stepped inside. The house smelled of other people, other cooking, other lives briefly layered over hers. It would take time to feel entirely like hers again. She had managed worse adjustments over a long life, and she would manage this one. She walked to the kitchen. Pauline's plants were still alive. The post was stacked neatly on the counter. The ceramic pot by the back door was where it had always been, but she had already decided it would hold something else from now on. The key was going to Pauline, with a proper spare cut, and nowhere else. She put the kettle on. Kevin stood in the kitchen doorway. He looked considerably younger than 40 in that moment. Not innocent, but reduced to something more honest than the version of himself he had been maintaining for the past 6 weeks. I'm sorry, Mum, he said. I know, she said. End of the month for the money. Proper notice for the tenants. We'll talk properly when you're ready for that. She made 2 cups of tea and handed him one. They stood in her kitchen and drank without saying much, and the quiet between them had the quality of something that was going to need time rather than words. Kevin left after an hour. Ruth washed the cups, dried them, put them in the cupboard where they had always lived. Then she sat at her own kitchen table, in her own kitchen, in her own house, and felt the particular, settled quality of being exactly where she was supposed to be, and knowing it without any uncertainty at all. The full rental income for 6 weeks was transferred to her account by the 28th of the month. Ruth acknowledged it in a message. She did not add anything further. The tenants at Clifford Avenue were given proper notice and moved out 12 days after the Wednesday conversation. Kevin managed the process without involving Ruth, which was exactly what she had asked him to do. He sent her a brief message when the keys were returned, and she replied with a single word of acknowledgement. She had the house professionally cleaned before she considered the matter resolved. It cost £200, which she deducted from her mental accounting of the situation without asking Kevin to cover it. She had recovered the rental income. She did not need to make the thing any larger than it already was. She completed her physiotherapy and was formally discharged 6 weeks later, walking without assistance, negotiating stairs without difficulty. Her surgeon was satisfied. So was she. She also called Gerald and asked whether the firm had any use for occasional consultancy, document review, file organization, the kind of precise administrative work that was difficult to replicate once experienced people left. Gerald said he had been hoping she would raise it. She began one morning a week, then two, because the work suited her particular skills, and because being good at something, and being recognized for it, turned out to matter considerably more to her than she had acknowledged during the years she had organized everything around being available to her family. Ruth thought about this sometimes in the weeks that followed, about the gap between the Kevin she had trusted for 40 years and the Kevin who had made the decision he had made. She did not try to reconcile them into a single explanation. People were capable of both things simultaneously, of being genuinely loving and of doing something that betrayed that love, of caring about someone and of deciding, under sufficient pressure, that the caring could wait. She had typed up enough family law cases to know that this was not exceptional. It was, in fact, the most common version of how families damage themselves, not through malice, through a decision made under pressure, in private, with the intention of keeping it quiet. The relationship with Kevin was careful for a long time. Phone calls once a week, shorter than they used to be, honest in the way that things become honest after pretense has been removed, and something real has to grow in its place. Whether it would grow into something warm again, she didn't know. She left the space for it and did not try to force it. She also replaced the lock on the back door and put the spare key somewhere other than the ceramic pot. She gave the new key to Pauline, who accepted it and put it on her key hook without making anything of it. That was exactly what Ruth had wanted. She thought, occasionally, about the version of events in which she had not had 28 years of family law behind her, in which she had been a person without that specific professional knowledge, who had taken Kevin's explanations at face value and gone on waiting and trusting until the tenancy had expired on its own terms, and Kevin had returned the key and offered some explanation she might or might not have fully believed. She thought about how many families had sat across a desk from Gerald Hargreave in situations that had gone on much longer than they should have, because the person who needed to understand their position had not had access to the right information at the right time. She had been very fortunate in what she knew. She did not intend to take it for granted. The notebook went into the drawer of the hall table, available if she ever needed it. She did not expect to. But 28 years of professional life had taught her that the most useful things are the ones you keep close before you know you'll need them, not after. If Ruth's story stayed with you, subscribe for more stories about women who knew their rights, kept their records, and were patient enough to use both at exactly the right moment. And tell me in the comments, would you have confronted Kevin that Wednesday evening, or let the lawyers handle all of it from the start?